March 6th, not at 10:30.
Judge, I can also call Mr. Angel Montes on page 7.
Actually, the week of the second week of March, I believe the judges are at Judicial College. I don't know for sure, but for now, let's not do March 13th, but you have March 6th. So if there's any change, I'm sure you'll get a memo. Next case.
Call Mr. Angel Montes on page 7 of your Honor's docket.
Yes.
Judge, so I just PDF'd him on his new law. He's currently being held on this case as well as the new law. The state is not willing to discuss in terms of the release together. I would ask if your Honor would be willing to put him on the standard profile or he doesn't have any history of violent crimes. He's on the thefts right now.
Do you have a copy of, did you file a motion to
I was
send?
just going to judge.
Okay, do you have a copy of his score sheet, probable cause affidavit, anything that the court can enlighten itself?
I can provide those to your Honor if the state can give a moment to review it. As you can see, your Honor, the case here and it approximately this morning without motion for me to review it, but I will provide your Honor with the score sheet and probable cause affidavit.
Okay, so we'll put it in recall. Next.
Good morning, Your Honor.
Good morning.
Here. I have on page 27 of your own docket, Amy Garman. Judge, we're set for set new dates. I know that Ms. Garman actually reached out to my office last week while I was out of town, and I believe she lives out of state. I did send her a waiver of appearance form, but I haven't received a signature back. But if I can waive appearance for the purpose of today's hearing, Judge, I would ask for a February 6th calendar call.
Your Honor, actually, this case is going to be transferred before we set that date. There's an older case in Division FD. So, Your Honor, I'm going to present the clerk with a transfer order. And I believe there's a date for the newer case February 3rd. February 3rd at 9 a.m.
So there's already a date?
Yeah, well, there's a date for the older case in that division. I was just asked last Thursday.
So we're going to transfer, and then this case is going to be set for that date?
Right.
Yes, Your Honor.
In front of that other division.
Correct.
Okay, sounds good.
Thank you kindly, Your Honor. Thank
So
you.
we're setting it for what for that date?
I think it's up for a calendar call on the call with the February 3rd date.
It's up to Your Honor.
I guess. I mean, it's going to a different division, so
Right, exactly.
I don't know what they have it set for.
And Your Honor, I can look into who is the RCC person in that courtroom, and I'll coordinate with them to make sure that
Okay.
they've done everything.
Thank you.
Thank you, Judge. I think that's all I have for you today.
If you can, Your Honor, just give the state just a moment to provide Madam Clerk with the transfer.
Sure.
Thank you. Okay. Thank you.
Let me just advise the Public Defender's Office that case Jordan Weiss has sent a message to the court advising that they live out of the state. They cannot be here in person. not allowed to travel.
Thank you, Your Honor.
So the Zoom link was provided to them.
Thank you, Your Honor, for giving us the moment.
Your Honor, if the court is ready, I would like to call Brian Brown on page 11 of your docket. Mr. Brown, Your Honor.
What page did you say? 11?
Page 11, Your Honor. Mr. Brown completed an application for the public defender today. It appears as if there is a change of charge date is outstanding, and we are asking to reset it for tomorrow.
State any objection?
I just want to know the purpose of the...
It's change of charge.
I understand the change of charge previously.
Yeah.
Okay. Just for
Yeah,
record,
I'm
I know
sorry,
that,
yeah,
I know we're all aware, but for the affidavit, no, Your Honor, no objection to reset.
So we're resetting it for tomorrow.
David, look at that David today. Come back tomorrow morning.
Anybody else? Good morning.
Good morning, Brown. Happy to meet you, sir.
Happy New Year.
Good morning, Judge. I was in for a while for this case.
Judge, Mike Zucker.
Yeah, I was there too. I remember you. Move us around. Here, good luck. Look, this is somebody else's card. I just crossed off their name, put my name there. Yeah, the first six are the same. The last four is 86 would be. That's how you get in touch with the leave a voicemail. Call me from office.
Overstate.
David to remain on bond. You want me to write it down?
The new statute that ended up in Veterans Court for this area. The new statute that the state proposed to objection. One of the Americans said, unfortunately, I can't accept the case. So we're back. I'm going to ask for this to be reset for the last 30 days. I've spoken this morning with Mr. Gonzalez. We never really got into the substance of some of the issues. I think there's some time that I have opportunities to perhaps discuss with the state whether that's an appropriate decision. So I was asking for a reset.
State any objection?
No objections to the reset, Judge.
What are we resetting it for? For status, calendar call?
So, I mean, today I know it's for set new dates. Obviously, we didn't have a date present. I'm fine with setting it for a status if you want, or a calendar call, whatever the purpose is.
Do you want a status?
Yes.
So you said 30 days. 30 days from today brings us to February 3rd. This division's being taken over by Judge Villalonga starting the 22nd. So I'll set it for that day.
22nd of January?
Yes. No. The division's being taken over January 22nd. The date that I'm setting it for is February 3rd.
Thank you.
So that's going to be before a different judge in a different courtroom.
We actually set it for a different judge. I apologize.
Okay, what day would you prefer?
I can do any other date that week. I'm out of the office on that Monday.
Okay, we can, any Tuesday, can we do Tuesday the 4th?
Tuesday, 4th is fine, right?
So February the 4th at 9 o'clock.
Thank you. Nice to see you.
Have a great day.
On this one.
Morning, Judge.
Good morning.
I have closing reminders on page 13 of your calendar. Happy New Year.
Happy New Year.
Honoring honor, Amanda Graham on behalf of the
What page?
13.
Yes.
We're here for a change of plea. Before we get started, Mr. Ramirez, of course, is down with the plea. He is surrendering to prison. So my question is regarding he's taking the plea and just surrender that surrender date in 2 weeks so he can get himself healthy and take himself in.
State.
Judge, I have no problem with that. We discussed that he was going to
5 years, the ultimate sentence is 3 years Florida State prison followed by 10 years probation.
Well, first of all, if he's sick with the flu, he should not even be here. So I don't even know why we're not resetting everything. We're here spreading germs.
You can reset it.
I just didn't want not to show Judge we were here for the plea today, so.
Okay. So reset it for 2 weeks.
Are you
Any
gonna be here in
specific
2
date?
weeks, Judge?
Huh?
Are you gonna be here in 2 weeks?
I'm going to be here, the 21st is my last day. So reset it for that day if you want. That's Tuesday.
Judge, I have a, Judge, can we do it on the 20th, the 21st, have to be in federal court?
The 20th is a holiday.
I can see if I can have someone stand in. I have a federal matter that morning. If it's okay with my client, I can have someone else stand in for me. We have a plea paperwork prepared, and I'll leave it with the state.
Okay,
it's all-
so we'll reset it for January 21st at 9 o'clock.
Okay, Judge.
Thank you.
Thanks. David Seltzer.
And by the way, Judge Diamont is not coming to this courtroom. She's just taking the division. I'm not leaving courtrooms.
Judge, it's okay. I don't want someone standing physically versus I'll be on Zoom that day.
That's
Just so I
fine.
can be present. Okay, sure. Thank you.
So let me get this straight, you're still gonna be doing criminal?
Yes,
Oh, all right, so that's cool.
I'll be taking
Just a
the
different division.
FP division.
Mr. Rodrigo, body, D, Arijo.
What page?
Very good.
What page?
I don't know.
Wait till he waves you off.
29.
I got it right here, 29.
Okay, we're here for
A motion for early termination of his probation.
do we
It's
have,
in the motion to clarify, I don't
I
know
don't
if it's
see,
for, yeah, because I don't think believe it's for early termination. I know within the body of the motion, there's a request gonna be a,
We got some other,
Well, there are things we'll ask and you'll say we can't provide. We'll go through the motions of what we need to do and we'll do what you need to do. But then a long time is going to have to be spent with him as to what he wants to do. I mean, that's not a 2-minute discussion.
no, I agree. So you haven't discussed it with him or?
no.
Got it, okay.
Because Raven is not even here today because she's been flying back from Montana since yesterday morning.
Oh, wow.
Are you presently under the influence of any drugs, medication, or alcohol? Have you ever been treated for a mental illness? So, Mr. Lavity, you're currently on supervision. It's 34 counts total. All right? Let me go through them real quick. We're ready. Thank you. Ready to go on the record? Yes. State you did?
Yes, Your Honor.
Okay, let me go back on the record. This is on the FD docket on the top of page 4. State versus Jamell Demons. I've got Ms. Buckaloo, Ms. Collins, Mr. Griffith, present for the state. I've got Mr. Yancey, Mr. Anderson present for Mr. Demons, who likewise is present. Mr. Aronson, you're telling me we're going forward without Ms. Liberty, without Mr. Benjamin, and without Mr. Higgins today. Is that correct?
Yes.
So, in preparation for the 2 days of all pending motions, I was going to put on the record, I know that the defense wants me to take one of these out of order. I think they're probably correct about that. But let me just put on the record real quick, everything that I've read in preparation for the all pending motions that I gave you all day today and all day tomorrow for. I endeavored to try to read everything in the electronic file, all filings and any authority cited therein. That took place since the mistrial was declared in Mr. Demons' previous trial, which was July 22nd, 2023. So these are all the pleadings that I read that were filed by the defense. I did read also all the orders that Judge Murphy entered, so I do realize some of these may be new, but in the abundance of caution, so I would be prepared. I nevertheless did read all of them. As we go through them, I'm sure you all will let me know if it's something that I need to resolve or something that's already been resolved. Defense, and I'll do these in chronological order. I read the defense motion to compel Brady material that was electronically filed August 23rd, 2023. I read the defense motion to compel discovery that was electronically filed August 31st, 2023. I read the defense motion for discovery of prosecutorial investigations and prospective jurors electronically filed September 6, 2023. Defense motion for disclosure of penalty phase evidence electronically filed September 13th, 2023. The defense's motion in limine regarding phone, social media, and business records electronically filed September 21st, 2023. Defendant Jamell Demons' motion in limine to exclude certain testimony of Detective Mark Moretti regarding Apple Health Chronometer electronically filed October 4th, 2023. Defense motion to exclude testimony of defendant's alleged gang affiliation electronically filed October 4th, 2023. Defendant Jamell Demons' response to state's motion to quash subpoenas and/or for protective orders, and for an order to compel witnesses to be deposed and to attend hearing, electronically filed October 4th, 2023. Defendant Jamell Demons' motion to compel discovery, electronically filed October 4th, 2023. Defendant Jamell Demons' motion in limine to exclude certain testimony of Detective Mark Moretti along with cell hawk, call, data, record, mapping, and Google Maps, electronically filed October 5th, 2023. Defendant Jamell Demons' motion in limine to exclude certain testimony of Detective Mark Moretti regarding Apple Health Chronometer, electronically filed October 5th, 2023. Motion to exclude testimony of expert witness and memorandum of law, electronically filed October 6, 2023. Response to state's motion to quash a memorandum of law, electronically filed October 9th, 2023. Memorandum Ray, ASA, Christine Bradley testified, electronically filed October 9th, 2023. Defendant's second motion for redeposition of Detective Mark Moretti, electronically filed October 29th, 2023. Defendant's second motion to dismiss for government and prosecutorial misconduct in violation of the defendant's due process rights.
Judge, that can be struck because we filed the third one and that incorporated the second. And we already have a ruling on the third one.
Okay, well, hold on. Let me get all of them done,
All right.
and then we'll go one at a time. That's why I gave you 2 days. This one is defendant's second motion to dismiss for government and prosecutorial misconduct in violation of the defendant's due process rights. That one was filed November 1st, 2023. Defendant Jamell Demons' motion to exclude, electronically filed November 2nd, 2023. Defendant Jamell Demons' motion to strike the state of Florida supplemental discovery, electronically filed December 14th, 2023. Defendant Jamell Demons replied to the State of Florida's response to defendant's motion to strike the State of Florida's supplemental discovery list, electronically filed December 17, 2023. Objection to business record certification and/or motion in limine, electronically filed December 18, 2023. Defendant's third motion to compel forensic images of the cell phones belonging to Christopher Thomas and Anthony Williams, electronically filed April 15, 2024. Defendant's request for status hearing, electronically filed April 15, 2024. Defendant's motion to set aside stay and/or modify stay to allow discovery to proceed, electronically filed April 25, 2024. Motion to compel discovery, electronically filed May 13, 2024. Defendant Jamell Demons' motion in limine number 2 to exclude irrelevant and immaterial YouTube videos of 1090J, electronically filed May 14, 2024. Defendant's motion to strike the State of Florida's motion for rehearing dated May 14, 2024. That is electronically filed May 14. And then a defense motion for hearing to determine potential conflict, electronically filed December 27, 2024. From the State Attorney's Office, I read the following. State's motion to refer to potential and seated jurors by number instead of name, electronically filed October 6, 2023. State's motion to allow former testimony of state witness, filed October 6, 2023. State's motion to strike State Attorney Harold Pryor, Assistant State Attorney Regina Falk, and Assistant State Attorney Christopher Kilran from Defendant Demons' supplemental witness list for trial, filed on September 29, 2023. This pleading was electronically filed October 10, 2023. State's motion to strike Assistant State Attorney Christine Bradley from Defendant Demons' supplemental witness list for trial, filed on September 29, 2023. That's electronically filed October 10, 2023. State's motion for admissibility of consciousness of guilt evidence and request for ruling prior to jury being sworn, filed October 20th, 2023. State's motion to withdraw State's motion to strike ASA Christine Bradley from Defendant Demons' supplemental witness list for trial, filed on September 29, 2023. That is electronically filed on October 25th. State's motion to withdraw State's motion to strike ASA Christopher Killoran, ASA Regina Falk, and State Attorney Harold Pryor from Defendant Demons' supplemental witness list for trial, filed on September 29, 2023. That is electronically filed October 25th. State's motion to withdraw State's motion to strike ASA Christopher Killoran, ASA Regina Falk, and State Attorney Harold Pryor from Defendant Demons' supplemental witness list for trial, filed on September 23, 2023. This is not a duplicate. This is an additional document, also filed on October 25th, 2023. State's Board Memorandum of Law, electronically filed October 30th, 2023. State's response to defendant's motion to redepose Detective Mark Moretti, electronically filed October 30th, 2023. State's motion to strike all jurors for cause with significant knowledge of the previous trial, electronically filed October 30th, 2023. State's motion for protective order and quash subpoena, electronically filed October 31st, 2023. State's motion limiting to prohibit defendant from improperly pre-trialing his cause or making misstatements of law during board hours, electronically filed November 1st, 2023. State's response to defendant Jamell Demons' motion to exclude, electronically filed November 6th, 2023. State's response to defendant's motion to eliminate phones, social media, and business records, electronically filed November 6, 2023. State's response to defendant's motion to exclude testimony of defendant's alleged gang affiliations, electronically filed November 6, 2023. State's omnibus memorandum of law in opposition to defendant's motion to suppress evidence, electronically filed November 6, 2023. State's memorandum of law raised striking jury panel due to defense misstatement of the law, electronically filed November the 8th, 2023. State's motion to strike the defendant's second motion to dismiss for government prosecutorial misconduct in violation of the defendant's due process rights, electronically filed November 28, 2023. State's motion to strike the defendant's unilateral setting of depositions and the state's proposed deposition and motion schedule, electronically filed December 16, 2023. State's response to defendant's motion to strike the state of Florida's supplemental discovery, electronically filed December 16, 2023. State's motion in limine to exclude testimony of Michelle Boutros and Christine Brown, electronically filed December 17, 2023. State's motion to strike the defendant's sworn motion to dismiss, electronically filed January 12, 2024. State's response to defendant's objection to business record certification and/or motion in limine, electronically filed January 23, 2024. State's motion to strike the defendant's request for status hearing and permission to proceed with litigation, electronically filed April 15, 2024. State's motion to strike the defendant's request for status hearing and permission to proceed with litigation, electronically filed April 17, 2024. State's response to defendant's motion titled Third Motion to Compel Forensic Images of the Cell Phones, electronically filed May 20th, 2024. I did also today do the state's motion to strike defendant's notice of hearing, electronically filed January 2nd, 2025, as well as the state's response to defendant's motion to compel discovery filed on May 13th, 2024, electronically filed January 2nd, 2025. As far as previous orders that Judge Murphy entered, I read all of the following. Order denying defendant's motion for redeposition of Detective Mark Moretti, entered August 7th, 2023. Order on motion to remove electronic monitor, entered August 25th, 2023. Order denying defendant's motion to set bond, entered September 22nd, 2023. Order denying defendant's motion to recuse State Attorney's Office of the 17th Judicial Circuit in and for Broward County, Florida, entered October 12th, 2023. Order granting defendant's motion to recuse 17th Judicial Circuit Assistant State Attorney Christine Bradley, entered October 12, 2023. Order granting State Attorney's motion to quash subpoenas and/or for protective orders, entered October 12, 2023. Order denying defendant's motion to dismiss for government and prosecutorial misconduct in violation of the defendant's due process rights, entered October 20th, 2023. Order on State's motion for inquiry of all pre-qualified jurors and motion for relief, entered October 26, 2023. Order granting in part and denying in part defendant's second motion for redeposition of Detective Mark Moretti, entered November 7, 2023. Order denying defendant's motion to declare section 921.141 subsection 6 of section N of the Florida statutes unconstitutional, entered November 14, 2023. Order on deposition of state witnesses, entered on November 15, 2023. Order granting the state's renewed motion to reset the trial commencement date, entered November 15, 2023. Order denying defendant's motion in limine re agreement between Demons and Williams as to sharing of any money, entered November 17, 2023. Order re second deposition of Detective Danny Polo, entered November 21st, 2023. Omnibus order on defendant's motion to suppress numbered 1 through 13, entered December the 20th, 2023. Order on the state's motion for rehearing / reconsideration, entered January 11th, 2024. Order on defendant's motion to dismiss for violation of due process and double jeopardy and/or motion to recuse entire state attorney's office of the 17th Judicial Circuit, entered January 19th, 2024. Order on state's motion for clarification, entered January 24th, 2024. Order denying the state's motion for reconsideration, entered January 25th, 2024. Order granting defendant's motion in limine re promotional video, entered January 25th, 2024. Order denying defendant's motion to set aside stay and order granting defendant's motion to modify stay to allow discovery to proceed, entered May 2nd, 2024. Order denying defendant's motion to set aside stay and order granting defendant's motion to modify stay to allow discovery to proceed. That's a duplicate. order denying the state's motion for rehearing and reconsideration of the court's order modifying the state to allow discovery to proceed, issued on May 2nd, 2024. That's issued on July 16th, 2024, non pro tunc to May 16th, 2024. So, that's everything that I looked at, as well as any authority cited therein, statutes, case law, or otherwise. You don't have to repeat yourselves, but you certainly can if you would like to. I have the balance of all day today. I take a lunch break between 12:30 and 1:45. I can likewise give you the entire day tomorrow. I won't limit either side to present whatever evidence, witnesses, or testimony they would like to present. Defense, I'm going to start with you, and I also did read Rutledge versus State, which is 157 3rd 830, regarding the defense motion for hearing to determine potential conflict. So, whenever you're ready, you may proceed.
Thank you, Your Honor. Rutledge and other cases, federal cases, because state court really hasn't delved into this area as much as the federal case law does, indicates that there are certain things we need to find out first of all. So I don't know if this is the hearing or you want to set a hearing, but the bottom line of it is that the first thing we need to know whether Miss Liberty is still under investigation. We were told before the hearing by the state, and I have no reason to doubt their word, that she still is under investigation. So that raises for us a number of problems. It may look on the surface that the only thing is, does Miss Liberty need to get permission from Mr. Demons to stay on the case and for him to waive conflict, but it's much deeper than that. And the reason why it's much deeper than that is we don't know what the state has subpoenaed. We do not know what they have in their possession. We do not know, other than the Apple accounts, if they've subpoenaed other things. Therefore, we do not know whether communications that we have had with Miss Liberty have been intercepted, and therefore, we've been told that nobody else on the defense team is under investigation, but there are certainly confidential communications that we would have had with Miss Liberty. There are communications about trial strategy that we would have had with Miss Liberty that we do not know who is in possession of them, what is going on with them. Now, the case law seems to be pretty clear that during this type of process with an attorney who's on a case, that the state is bound to return innocent or innocuous or confidential communications to Miss Liberty. But she has not received any. In fact, she didn't know there were any that were to be received until the date that's mentioned in the motion. So where does that put us? As I said, we've been told that the defense team, other than Miss Liberty, is not under investigation. But we do know that there's an ongoing investigation. What we have now been working for nearly a year, or over a year, with the state being in possession of documents dealing with Miss Liberty. If in fact Miss Liberty has to get off the case because of the conflict that she would have, this is a year too late. We should have been informed of this a year ago. So the defense team and Miss Liberty, and therefore Mr. Demons, for a year are working on this case with the state knowing that there's the potential that Miss Liberty will be indicted or an information filed against her in the exact same case of tampering with evidence and with witnesses. And if that becomes the case, she obviously, whether there's a conflict or not that has been waived up until that time, I think the case law is pretty clear. At that time, if she has charges against her, she has to bail out. In fact, I believe, and I'm not sure because it's federal case law, but I'd like to read to the court this paragraph from the case of U.S. versus Shagan, 661 Fed Sup 1289, 2009. In contrast to McLean, where the defense counsel was under investigation for a crime unrelated to charges against the defendant, here, defense counsel would have been under investigation for crimes that threatened the integrity and fairness of the trial. Were the government to inform the court at the eve of trial or during the course of trial that the defense team was under investigation for witness tampering. Under the principles of McLean and as conceded by Cronin, the defense team would be forced to withdraw its representation of Dr. Shady. In fact, David Marcus made the motion orally as soon as he heard about the investigation. Such a development would have deprived the defendant of a defense team that had been intimately familiar with his defense, causing him severe prejudice. And that's where we're traveling down right now. Even if we stay on the case right now, if charges are brought against Miss Liberty, and they happen to fall before the end of Mr. Demons' trial, we may be forced to, under the law, to withdraw as an entire defense team. But a question still needs to be asked. Why did the state wait, not to tell us, because they never told us, we had to find it out through Apple, that there was an investigation? Because a year ago, we would have sat with Mr. Demons, and he may have said, you know what, I need a new defense team. And we would have been off the case. But for a year, basically, we've been on a case that maybe we should not have been. There are things that we need to know. We need to know who reviewed the warrant, who signed the warrant for the state as far as authorizing. We need to know whether there was a tainting. If all this information was gathered and given to the state attorneys that are prosecuting this case right now, there are innocent, innocuous, and confidential communications that will be in the hands of the state that is improper. A tainting should have been set up that reviews the documents and makes sure only those that are specific to the search warrant are looked at by the trial team. Questions need to be asked. If in fact Ms. Liberty is under investigation, then why were the subpoenas sent out and why did that investigation begin now? And what I mean by that is there's a statute of limitations. The state was under no obligation to begin that investigation until Mr. Demons' case is over. Therefore, there is no perceived conflict. There is no conflict because we don't know that they're thinking about investigating Ms. Liberty. But instead, we were not put in that position to know that, and a year went by. If they had waited to the conclusion of Mr. Demons' case, as I said, then there is no conflict. So the only thing that I get from this is that there's the chance that within the next whatever year, or 10 months until the trial date, 9 months, whatever it is exactly, that Miss Liberty is in fact facing charges formally. And if that occurs, then A, she can't try the case. Not sure the rest of the defense team can try the case. And don't know, and a prejudice to Mr. Demons would be monumental that at this late stage you'd have to get a whole new defense team. So we need these questions answered. It's not just as simple, is there an ongoing investigation? We need to know the extent of it. We need to know the whys of when it was instituted and why wasn't it, why didn't the state wait for this matter to be over? We need to know whether the state, if they're going to charge Miss Liberty with this crime of tampering, do they intend to try her at the same time as Mr. Demons, or a separate trial? Obviously, at the same time, it even raises more of a conflict. We have a question, and that scares us. Miss Liberty has not been allowed to see Mr. Demons in person for the last, before I got on the case, for at least the last year and a half. When she goes to the jail, she must pick up the phone and use one of those phones to talk to Mr. Demons on the other side of the glass partition by phone. Have they been tapped? Have they been listened into? We need to know what communications, what has gone on. So it's not just as simple as, is there an open investigation? Now, as far as going forward on these other motions that you said, We can't go forward as a defense team on any of these motions until we talk to Mr. Demons and have him understand what's going on. And for him, first of all, to make the decision. Yes, I want to keep this defense team. Yes, I want to keep Miss Liberty. Or no, I need a new defense team. We can't do anything until that's decided. I will say that after doing the research that I did over the weekend and came up with the case I cited to the court, I think all members of our defense team need to call up the Florida Bar and to see whether we're obligated, now that we know that she's under investigation, that we're obligated or not to withdraw from the case, regardless of Mr. Demons' position. So that's where we stand today. With all apologies to the court, though, I do not believe we can go forward with these motions. Mr. Demons has a lot of thinking to do. Hopefully the court will give us a hearing if some of these questions are answered, and then he can make a logical and an informed decision. And by that time, we can find from the bar whether we have obligations regardless of his decisions.
Rutledge says, I have to find out if there's an investigation, and the state says there is. What is your authority for all those other things that you said you want to answer? Because I didn't find any authority in that. I don't even know how I would do that. Well, do you have any authority? I understand you're saying, Mr. Judge, this is what we'd like. I read what Rutledge says. That's what I'm doing right now. But you want to know about investigations. You want to know about a judge who reviewed a warrant. How would you suggest I do that? And more importantly, do you have any authority that supports any of those requests you just made?
Well, the authority that I have, Your Honor, is the Sixth Amendment to the United States Constitution, which requires and which allows my client to have competent counsel. And without being able to go into these things, and I also rely on the 14th Amendment due process, without being able to go into these things and have a hearing where all these things are ferreted out.
A hearing, that's what I'm asking. What do you I don't want you to confuse some type of hearing defending this liberty. That's not really the issue. That's a yes or no question. Is she under investigation? And the answer is yes. So the only other question that Rutledge requires is that Mr. Demons has to decide, does he want to go forward with her, or does he want conflict-free counsel, which I think he's certainly entitled to. And if he wants to apply that to all of his lawyers, he may do that. But that's a discussion between you and your client. I can't intervene in that. You're asking me to do fact-finding on behalf of your clients, or your client can make an informed decision.
Well,
right?
I will file another motion for prosecutorial misconduct and ask for a hearing on that. Subpoena witnesses in. The state will move to quash the witnesses that I will be calling in, and we'll have hearings going down that path. But this is something, no offense to this court, but I do not know how this court says that's the only thing that matters to me. There's a whole laundry list that deal with not only conflict.
That's what I'm asking. Do you have any case law that tells me I have to do that? I'm happy to do that. You cited Rutledge, and I read Rutledge. Rutledge doesn't
I
say
have
any
no
of those
case law in
things.
front of me right now that says you have to do that. But I would think it would be the inherent authority of this court that you should do that. And there's certainly nothing that says you can't do that.
That's usually that podium that talks to me about my inherent authority, which I don't exercise. I'm happy to do whatever a statute, case law,
Well,
criminal procedure tells me to do. I don't make up things on my own.
Then I ask the court, let's go one step at a time. Right now, Mr. Demons now has been informed that Ms. Liberty is under investigation, and let us see what he decides. If he doesn't want us on the case anymore because of this, then all the things I've raised will be raised by another set of counsel. But if he does, we will be filing other motions in order so that we can get these questions answered, because Mr. Demons needs to know these before, quite candidly, he can make that choice. He can say right now that he wants Miss Liberty, but after these facts come out, depending on what those facts are, he may decide he doesn't want Miss Liberty or the rest of the defense team. So we'll take it one step at a time.
So your request is you want me to hear any of these today? And
I don't think we can.
when would you like me to reset them?
I do not know how long it will take. Miss Liberty is not in town yet right now. She's on a plane. She got snowed in Montana yesterday. Drove from Montana to Seattle. She was on an airplane ready to come here, and they canceled the flight while she was on the tarmac. She got another flight and flew to Phoenix. She's now on a plane from Phoenix to here. Almost all these motions that you went through are Miss Liberty's motions. So A, for logistical purposes, we can't hear those motions this morning at least. We're hoping that she's back at 1:30. But I do think It takes some time for us to talk to Mr. Demons. She certainly needs to talk to Mr. Demons. So, you know, you want to reset it for, I don't know if we can speak to him tonight sufficiently or not. You want to put it on for possible motions tomorrow and status tomorrow? You can, but I'm not sure that's enough time to talk to him.
It's not enough time when you can't do it. And we need to know, if I may.
Yes, sir.
We need to file, based upon your Honor's comments, we need to file a motion requesting certain things about this investigation. Concerning the tainting, whether or not they relayed any of that information to the prosecutors or the investigators in this case. And I want the court to know, they didn't tell us. Apple informed Miss Liberty that a search warrant was issued on her Apple account back on December 13, 2023. As a result of that, I contacted the Broward Sheriff's Office and spoke to Christian Sabanis. And I sent him a text message that said, I was just advised that Broward Sheriff's Office issued a search warrant on Miss Liberty's Apple account on December 13, 2023, over 1 year ago. I would like to discuss this with you. He responded by saying, hi Stu, I have zero knowledge of this search warrant or its application. Your email is the first I have heard of this. I would defer to whoever the affiant was. I don't have access to that information. I in turn contacted the state, and they said they would get back to me, which I spoke for the first time this morning to the state concerning this. I think we need to know the procedure of the so-called tainting so that any privileged communications were not relayed to the prosecution team and or its investigators. We also need to know why, since Miss Liberty represents numerous other clients, whether or not they have severed or separated those privileged communications that have nothing to do with their so-called investigation. We need to find this out.
Well, do you even know the investigation has to do with this representation? That's exactly what I was just thinking, what you just said.
I assume it is, since it's issued from the Broward Sheriff's Office.
How do you know it isn't related to one of our other clients or one of our other cases?
Well, that's all I
have. Has anyone said
have.
anything that this has anything to do with Mr. Demons?
I can't answer that without seeing the search warrant.
And we're not here to make work. Does this have to do with Mr. Demons?
It does, John.
Okay.
So, can you give them a copy of the search warrant?
No, because it's a pending investigation that's still ongoing.
How does Mr. Demons make a decision about whether he wants to waive any potential conflict or not without having that information?
The only thing I can say, Your Honor, is again, it's a pending investigation. Knowing that she's under investigation is what Rutledge talks about. You can't give anything over until it's officially completed.
With all due respect, Ms. Bucko, this is the high due process part when the state's seeking the death penalty. The state's seeking the death penalty. So you need to turn over the affidavit and the search warrant so the lawyers can make an informed decision. All right?
It does not have to do with the homicide case.
Well, in any case, he needs to know if there is a potential conflict of interest. He's either going to make an informed, intelligent waiver of that, or she will no longer be his lawyer. And then he has to make the same decision for all of his other lawyers. And he is going to trial September the 10th, 2025. So we need to do this now. So how long will it take for you to get a copy of the affidavit and a copy of the search warrant and give it to opposing counsel?
I'll have to speak with my office, and if you can have a week to figure this out.
Judge, they've had since December of 23. They didn't even have the courtesy to inform us of a pending investigation. We had to learn this from Apple.
you're telling me it relates to this case.
To the tampering case.
So why would this be different than any other search warrant in any other criminal case? The defense counsel would be entitled to it.
Because she's not a subject that's been charged yet, potentially could be. It's pending investigation. All I can say is, again, pending investigation, there is a team in place, and it's still pending. So it's not like we have to hand over discovery to her. She's not a listed defendant yet.
No, but let me repeat myself. Mr. Demons has to make an informed decision about who he wants his lawyers to be. He's now been sitting in our jail for 2,159 days. So how long would you like to be able to make that decision?
I can't determine when the investigation will be over. That's up to the Broward Sheriff's Office, but I can, as I said, I'm just asking for a week to determine whether or not we need to file any sort of motion to prevent the search warrant from being over.
I just can't imagine any legal grounds that would not happen in this particular case. It's a death penalty.
I understand
It's a
that.
death penalty.
And then I'm asking for at least a day or two. At
You
minimum.
decide by tomorrow. I've also reserved all of tomorrow. I took over Division FT. Judge Murphy had 44 pending first-degree murder cases. I've set them all for trial. I'm booked to trial through July of 2026. So if you all think I have 2 entire days at some point in the next 18 months to do these again, I do not. So
Understood.
I'm not sure what it is you want me to do. You don't want me to do anything else today.
We can't.
We can't.
We can't, under the Florida rules.
So do you want me to leave them on for tomorrow? You will have the balance of today to discuss all these issues with Mr. Demons, and state you will have the balance of today to discuss some reason why you can't just turn over this affidavit and search warrant?
That's
I
fine.
mean, it may be something innocuous. By the way, for the record, I don't know anything about this. No one brought me a search warrant, so, but maybe it's something so de minimis that Mr. Demons is going to say that's fine. If there's any conflict, I'll waive it, and let's get to work. Or if not, I guess he's going to have to go find 5 other lawyers to do this who are going to be ready to try a capital case in 9 months. So how about tomorrow at 9:30?
We'll be here.
Stay tomorrow at 9:30?
That's fine, Judge.
And it can't, again, I'm not picking on you, but the answer can't be, my office told me XYZ. Someone better be standing here with some authority that tells me they can't do it. Okay?
Judge, one other thing.
Yes, sir.
You mentioned about the trial schedule, and we're obviously going to try to do it. I just want to let you know, the matters that were appealed are still up in front of the 4th DCA. The state, I believe, just filed the last document in the case, or there may be one more that they need to file, one more reply brief. I would suspect that it's going to be set down for oral argument, and then I don't know when we will get a ruling. The problem is, the stay that was issued by your previous judge, we cannot go into anything on any type of discovery as far as depositions, as far as motions, as far as anything dealing with the matters that are up on appeal. So when that all comes back, we will be rushed to get everything else done. Just want to let the court know, we're under the mercy of the 4th.
Is there anything pending at the 4th DCA regarding the tampering?
Yes, everything that was on the homicide is also on appeal for the tampering because it's the same evidence.
Yep.
And Judge Murphy entered an order.
Entered an order that says you can't do depositions?
We can do depositions on things that aren't on appeal. So we have been doing depositions on things that aren't on appeal.
For example, you did not read, unless I missed it, but there is a motion in which I'm asking the court to make the state tell us what of the 2 million or whatever amount of Instagram messages they intend to use at trial. That was filed a long time ago. We can't have that hearing because the Instagram messages, the whole thing is up on appeal. So we can't even go into that motion. Those are some of the things that await you.
Well, couldn't I give you rulings on all those, depending on what, if I rule some messages are in and some messages are out, for example, and the 4th DCA says they're all out, then they're all out.
Judge, I wanted to move this case. I'm just...
Do you have any objection to doing that?
We're not the ones that filed this day.
Do you all have an objection to doing that?
Well, I think I'm confused on the motion that you're bringing up because all of the Instagram, if I remember correctly, I'd have to look. is up on appeal.
Right.
So, I mean, it would kind of be a waste of time to do the motion.
Oh, no, a waste of time is reserving 2 entire court days and doing nothing. That's a waste of time. So do you have any objection to going forward and me hearing and ruling on any and everything that's pending?
I think that we should start with the things that don't affect the appeal, and then, because there's plenty of those to be heard, and then we can go forward potentially with the other ones.
And I'll be candid, I did not think we were hearing the Instagram matter whatsoever. So I just have not looked at that motion.
Okay, so why don't we do it this way, all right? He's going to remain on the docket tomorrow. I have a few other matters on both FX and FT, so let's call it 9:30 tomorrow. And defense, you can come in and tell me if you had a chance to talk to your client, because if he's going to waive any potential conflict, then I guess it doesn't matter.
Yes, it does, Your Honor, because he'd be waiving a conflict without knowing what's in the search warrant affidavit.
Correct.
So therefore it would be an invalid waiver because he's not totally informed of the facts.
Okay, you're going to tell me what you want to do, state, maybe you can identify the motions that you think we can go forward. I mean,
We sort of addressed it in the motion to strike the notice, because we've been asking since our hearing in October to know what motions are going forward the next 2 days. Couldn't get an answer. We've asked in depositions for Ms. Liberty, couldn't get an answer. We emailed, we couldn't get an answer. And then just a few days ago, we got a notice of hearing. Half those motions aren't even filed within the court file in Odyssey. So we identified, I think, 4 that we are ready to go on, that we filed responses on. There's no motion filed for somebody's
you're going to go to trial.
title.
I'm not prejudging things.
I hope so, Judge.
No, I can absolutely guarantee you, he's going to go to trial in September. So I'm going to do everything that I can. If I have to rule on things during trial, which is an awful way to do things, because I know you both know, but if that's what it comes to, then that's what we're going to do. So,
Assuming we're still on the case. And that's a big assumption at this moment.
And just, they're still asking for proper notice of what we're actually
I
going to
did,
hear.
well, I'll take the blame for that. All pending motions. That's why I put that down to the tomorrow. All pending motions. They're asking for I believe, they're asking for a Daubert hearing on cell phone records. They're asking for a Daubert hearing on some other matter, cell phone mapping. There's a whole bunch of things that they
Some of those have already been ruled on, Your Honor. The ones that they've noticed, I think, and again, Ms. Liberty admitted to this the last time we were here in front of Your Honor, that she filed things with the wrong case number, wrong title, and she's going to fix that. None of it has been fixed. So the state is entitled to proper notice so that we can respond accordingly.
We'll see you tomorrow morning. Fair enough?
Okay, I'll see you at 9:30 tomorrow. Ms. Wilcox, does that otherwise conclude FX and FT for today? Okay, so the FX and FT are both going to otherwise be in recess until tomorrow, which is?
Excuse me.
Yes, sir.
I've been told that Mr. Demons has federal court tomorrow morning on his civil hearing. Does corrections have any idea of that?
Not tomorrow, sir.
Huh?
It's not tomorrow.
It's not tomorrow?
I believe it's January 17th.
17th. Forget what I just said. Thank you. We don't represent him on that.
Tomorrow is Tuesday, January the 7th. FX and FT will be in recess until then at 8:45 a.m. I hope you all have a good rest
Thank
of
you.
your morning. All right, Mr. Court Reporter, that is it.
Here.
At the gym.
Thank you. Thank you. May we be excused?
Yeah, we're in recess. Have a good morning. Use your time wisely.
Yes, sir.